is now being recorded. Welcome to the 5th webinar for the Technical Assistance for Excellence in Special Education webinar. This is the webinar number 5 for dispute resolution. I'm glad you could join us today. My name is Tina Spence. I'm with the State Department of Ed, Director of Compliance and Monitoring, and we will have several others assisting us through this process today. We will have Norm Ames from the Technical Assistance for Excellence in Special Education assisting. Colin Rayleigh from the State Department of Ed, Dispute Resolution, will be also spending a little time talking about what we have going on here in Oklahoma. Joanne Blades from Special Education Resolution Center is joining us, along with Sharon Long and Ellen Kimbrough from Oklahoma Parent Center. So our purpose today is to help understand the components of a general supervision system, and also in how that general supervision system affects the directors in the school districts. And at the end of this, we will have time for any questions that you may have to make sure that you leave fully understanding all the options that you have available. So here you can see the list and the dates of all of the webinars that we have had up to this point. And then we'll have one more after that on April 15th. We will have a Leadership and Management will be our final webinar series with this. If you are wanting to go back and look at any of the other topics that have already been recorded, they are posted on the State Department of Ed Special Ed webpage under News and Memos. And then if you scroll down on the News and Memos page, there's an LEA Directors Webinar Series. They are listed underneath the LEA Directors and Webinar Series, that you may go back and look at some of those and view those webinars. So the handouts and resources are listed. We did mail out the handouts earlier today, but if you did not get them, they are located on the right-hand side toward the bottom, so you can download those. They will be referenced some throughout this presentation, so it will be helpful to have those handy, and there's a list of them there that you can expect to have in your information packet. So our outcomes for today is wanting to make sure that all of the school districts can identify dispute resolution as a responsibility that the State Department of Ed has, be familiar with specific federal and state regulations on dispute resolution, understand the importance of dispute resolution and the procedural safeguards, and be familiar with the different options that Oklahoma has to offer to assist you guys through those things.
All right. Well, I guess that's my turn, Tina. I'll take over at this point. My name is Norm Ames, and as Tina mentioned, we here at the Center for Technical Assistance for Excellence in Special Education, or TACE as we affectionately call it, one syllabic word with a lot of letters in it. We're excited to be here with you all and partner with the State of Oklahoma State Department of Ed on this topic. And we're excited to talk about this topic with you. We know your time is valuable, and so we're grateful that you're here and hope that this webinar is useful to you in providing you some pertinent information to help build your capacity as local leaders. One of the first things we like to do is have you, if you're able to, get on your device and have you respond to a poll question here, a little bit of interactive opportunity here. One of the first things we like to ask everybody is to, let me just reopen it here. If you could go ahead and let us know what role you play as you're listening to this webinar. Are you a special education director at the district level? Are you a coordinator, a classroom teacher, aided service personnel? Good information to have, and we see that you know that a few of you may have multiple hats, and that's great. Bless your hearts. Looks like the majority of us are special ed directors and a few teachers. That's wonderful. We got a principal in there. I imagine that some of you are, like I said, play various roles. So let that go for another 15 seconds or so and see who we get. I'm a recovering special ed director myself out of the state of Washington. Kind of grew up in the Washington state system. School psychologist by trade, and fell quickly into the role of administrator, and I loved it. Very challenging job, and so we respect those of you that are out there doing this work. It's very important work. So it looks like I didn't click the broadcast button. So there you go. If you can see that, you can see who your fellow participants are as it relates to the various roles and responsibilities we have on the webinar here. So thank you for that. I'm going to close that one. Let me ask you one more full question, and this one relates to a brief self-evaluation of your level of expertise on the topic of dispute resolution. So go ahead and just rate yourself. Is your level very low, or is it low, somewhat familiar, very familiar, or can you take over this webinar here from Norm, which I'd be happy to let you do so. Let me know if you're an expert. That'd be great. We kind of want to get a feel here before we start into the content of where we stand generally. So we got a lot of folks that are somewhat familiar, and it's understandable that there are some low and very low ratings out there, and we do have a couple experts. That's great. So I'm going to find out who you are. Keep me straight if I say something dumb. Okay, well, thank you very much, everybody. We hope that by the end of the webinar here in the next 60 minutes or so, that you might find the courage to rate yourself a little bit higher. Maybe you'll move up on the scale a little bit more. That's our goal anyway. So thank you for that, and let's jump into the webinar. Here at TACE, one of the things that we do, we have relationships with several states across the country and school districts, and we like to make sure that we're always grounded in the big picture and then in the state context and, of course, the local context. And so most of you know this, but we just wanted to provide the big picture around the regulations. And so this topic today, while it cuts across several sections of the IDEA, it primarily connects to the procedural safeguards in Section 615 of the IDEA. And of course, as many of you are familiar with procedural safeguards, due process related activities, they kind of cut across several different sections of the regulation. So we got Subpart E, Chapter 300.500 and 300.530 around discipline procedures. And so these are just sort of FYI. We wanted to give this to you if you ever find the need to refer to these regulations, which oftentimes you should. There's that information. And then many of you have probably seen this graphic, but the Office of Special Education Programs at the Department of Education, or OSEP, developed this graphic a number of years ago to kind of help illustrate the interconnectedness of the various responsibilities that states have, state education agencies, around implementing the general supervision requirements of the IDEA. And so, of course, this topic, effective dispute resolution, resides on one of the puzzle pieces, and it's very much connected to other components of the general supervision responsibilities. And so it fits within a system of oversight, of accountability, of providing support and technical assistance to LEAs that overall that the state is tasked with doing in the eyes of Congress and federal regulations. And so again, kind of sticking with the big picture, with the reauthorization of IDEA in 2004, Congress made a pointed effort at trying to express the desire that federal dollars are to be used for the purpose of improving educational results for children. And as it relates to the IDEA, of course, children with disabilities. And so it seems to be, and as many of you know recently, OSEP not so much recently anymore. In fact, all along it's been a focus, but results-driven accountability, results-based accountability, all of these efforts moving away from a compliance-only focus to one that also integrates and expects actual results improvements on on behalf of students, that's a focus across the regulation. And of course, dispute resolution may or may not have a direct relationship with a student's improved outcomes, but it could, it may. And it's an important piece of that overall pie. Section 615 of the IDEA, as we mentioned, sets forth the procedural safeguards. It's all about protecting the rights of parents and students, as well as just protecting the system. It also is a way to ensure that school districts are able to demonstrate that they're doing the right thing as well. Procedural safeguards provide mechanisms, and so dispute resolution mechanisms, so that two parties, typically schools and families, are able to resolve disputes between each other, are unfortunately a reality of the process of educating our children, and particularly special education. And I would suspect that many of you are like me, where if you have worked in special education for a while, it seems like while we may be only educating a small portion of the overall student body, or at least special education touches, whatever the percentage might be in your state, 10, 11, 12% typically, that the litigation that's involved is overly represented within the realm of special education as compared to general education. And it's just inherent. It's just the reality of the sensitivities that are involved in identifying and placing and educating students with disabilities. It's important that we're aware of these different procedures and processes under the IDEA to help prevent disputes. State Education Agency requirements, SEA requirements, so states and LEAs that receive federal dollars to implement special ed programs are required under the law to have 4 very specific processes or options to help resolve disagreements that might occur under the IDEA. And these are the 4 formal, oftentimes you'll hear them referred to as formal processes. And these are not in any particular order, although they're kind of interrelated. But the first one that we'll talk about is written state complaints, and then mediation, due process complaints, which is the precursor to a due process hearing if it goes that far. And then the fourth one, again, which is kind of related to due process complaints, is something called resolution meetings. So written state complaints, what is that? And it pretty much is just what it sounds like. It's a letter that is typically written, it's written to an official state agency or state Department of Education typically. And I know you'll hear from the Special Ed Resolution Center here shortly, and they'll talk more about this. But basically the written statement spells out a violation or a problem that was observed or experienced. And written complaints are typically involve the following basic requirements or components, and that is that anybody, any individual or any organization is able to file a complaint and basically alleging that a state or a district has violated some requirement of the IDEA. In doing so, whoever is responsible for filing the complaint, they must provide a copy of that complaint to the school district or the public agency serving the child. Complaints, like I mentioned, are written, they're signed. They must be clear as possible in setting forth what the allegation is, what the complaint is. The complaint must allege, whatever it's alleging, that violation must have occurred not more than 1 year prior to the date of the complaint. So that's an important piece to remember. And then once the complaint is receive, the date of receipt to the state initiates a process, and the resolution must be complete within 60 calendar days from the day of the receipt of the complaint. The complaint process, might talk a little bit more about this, but it may or may not involve an on-site component to it. And so the state might send in a complaint investigator into the district if needed to, for the purpose of gathering facts and data and information, but it may not require an on-site visit as well. It all just depends on the nature of the complaint and what's required to get the appropriate information in order to render an appropriate decision. So let's move from written state complaints into mediation here. So mediation, again, it is what it sounds like, and it's in the scheme of due process options, and then in the world of dispute resolution, mediation is viewed favorably. It's generally thought of as a positive option as opposed to other things. Mediation is a voluntary process. It's not required that anybody go through this no matter what, but it is required that it's an option made available. Typically, parents of students with disabilities and the school district, as it suggests, will meet with a mediator, a specially trained person, impartial person that's familiar with the laws and is able to ferret out facts and figures and gathers information from both parties. Like I mentioned, mediation is generally viewed as a good alternative to other more severe processes, such as what we'll talk next, the due process complaint process or due process hearing, which can feel a little more adversarial. And so if there's something we'd have you take away from your understanding of mediation is that it's a little more positive option. It's a good option. It's most of the time, well, every time it's less expensive. There's just lots of different kinds of benefits to a mediation process. And mediation is able to be requested by either party at any time in parallel to or at any time during any of the other dispute resolution processes that might be going on at the time. So that's another important piece to remember. And then finally, the goal is, and what will happen is if mediation is seen all the way through, because it is a formal option under the IDEA, mediation does result in a legally binding agreement between the two parties. So that's important too. Due process complaints, and I mentioned that this is sort of the first step. If it continues, it could result in what's called a due process hearing. Process complaint is similar to a complaint, a state complaint. It's a letter filed by an individual that relates to a specific dispute or disagreement. One point of clarification with this type of complaint is that the area of dispute needs to rest within one of these four primary components of the procedural safeguards, and that is identification processes, evaluation procedures, placement processes, and then of course the provision of a free and appropriate public education. So implementing a special ed program or FAPE. For it to be a due process complaint, it needs to fall, the complaint of the instant point of disagreement needs to fall within one of those four sort of buckets under the IDEA procedural requirements. Now, related to due process complaints, and with the reauthorization of IDEA in 2004, this thing called resolution meetings became required as a component to a due process complaint procedure. And so what happens is school districts must convene a resolution meeting within 15 days of receiving a due process complaint. And it must occur before the school system initiates a due process hearing. So the purpose of the resolution meeting here in this case is is it's to provide one more option, one more instance, one more sort of piece of hope that parents and the district can come together, talk about the facts that form the basis of the complaint, and provide another opportunity to try to resolve the dispute without going all the way to a due process hearing. Typically, due process hearings are, as I think I mentioned that earlier, a little bit more adversarial. They will usually involve attorneys because the two parties have not been able to come together personally or directly to resolve the complaint. And so you get attorneys involved, and oftentimes that escalates that level of, or that feeling of adversarialness about it. And so resolution meetings are, I'm not surprised that they became required in the eyes of Congress and the folks that put the act together, because it's just another good option. And since it is required, there actually are two ways that a resolution meeting can be waived, even though it's required. But it requires simply that both parties, so the school and the parents, need to agree to waive the meeting, and it needs to be done in writing. And related to that, both parties could agree, even though it's a due process complaint, they could agree to defer resolution in a mediation setting. And so mediation can play a role here too, similar to what the resolution meeting might provide. That does result in a legally binding agreement, mediation does. So interestingly too, one more thing about resolution meetings is that convening a resolution meeting is not required if the school district is the one that files the due process complaint. But it is required if the parent files a due process complaint. There are other ways that are not formal, that are not spelled out in the law, that schools and parents and other parties can, engage in a process of dispute resolution and coming to agreements. And I know that in Oklahoma you have these options, and one of those is a facilitated IEP option, and it's, like we mentioned here, it's not in the IDEA, it's not a requirement per se, but it's just a good practice, and it's become something that is spreading across the country more and more as districts and families see the benefits of this. It's being used more and more. And what's happened, in your materials, you'll read one of them is an article, and you'll also see some data and the trends that suggest that formal options of dispute resolution and the frequency with which we're seeing due process hearings and those kinds of things are actually declining, even though it doesn't feel like it. And nationally, it is declining, and it's because of these more appropriate alternative methods for dispute resolution. And in your materials, and I want to say, let's see, as you look at your materials document, if you've got that in front of you, a lot of these resources come from the Center for Appropriate Dispute Resolution in Special Education, or CADRE, as we like to refer to them. They are a wonderful resource. They're a national center. They provide a lot of great resources and information to states, but I think it's also really good for district leadership to be aware of these folks. If you got your materials document available, click on your bookmarks, and you can see a chart called the CADRE Continuum of Dispute Resolution Procedures. And it's interesting to sort of study that chart, and you can see how they've conceptualized this continuum. On the left side, you can see stage 1, which is all about prevention. And within the prevention stage, they emphasize parent engagement, participant and stakeholder training, stakeholder councils, collaborative rulemaking. And in stage 2, when you get into disagreements, talking about parent centers, receiving help from your parent center at the state level, both with the family and with the school district. I know I engaged frequently with my local parent center representatives as a special ed director, and they were an amazing help to both of us. And then progressing through states 3, 4, and 5, you can see where these more formal dispute resolution options kick into play. And the idea is that as we progress as a group through these stages, that unfortunately the relationships deteriorate. You end up getting outside parties involved, whether it's a mediator or even attorneys, and then the state, and then ultimately, I suppose the feds could get involved at some point. So it's just a nice little way to conceptualize and think about this process. And then the next chart in your materials, it's page 128 is what I'm looking at. It's called A Quick Guide to Processes. And again, it was put together by Cadre, and it's a nice, I print this thing out and I have it on my desk as a special ed director, and not that I was involved in a bunch of instances, but it's just good information to refer to. It's a quick look at different options that are optional but also required under the law, and can give you a quick reminder of what's required under these processes and procedures. So there's that. And there's some other information around an article, and then Cadre wrote a nice thing about facilitated IEP meetings as an emerging practice. Even though it's not so emerging anymore, it's there, and it's being nicely used. And then information about the trends in dispute resolution, which I talked about. So feel free to look at those materials and become familiar with those. And I'll click through these slides here. So that is what we call, I think, the big picture, the federal perspective, a brief overview of the regulations and the major components of dispute resolution as it relates to the IDEA. And with that, I'd like to go ahead, and I think I'm turning this over to Colin at the state.
Thank you, Norm. My name is Colin Raley, and I'm a Special Education Dispute Resolution Specialist here at the Oklahoma State Department of Education in the Office of Special Education Services. I'm going to give you a brief overview of our written state complaint system. So as Norm has mentioned, we have several conflict resolution options that the state allows: IEP facilitation, mediation, due process, facilitated resolution, and formal written complaints. I'll give you some more background on formal written complaints. As Norm said, written complaints stem from the state's general supervision authority, and it is a less adversarial process that is provided at no cost to the complainant. And one of the main differences between a written state complaint and a due process complaint is that in a due process, the burden of proof lies with the party that brings the complaint. In a written state complaint, there's no proper burden of proof in that sense, but once the allegations are made and it meets the requirements to open the complaint, the state is able to investigate until we can make a determination. So a formal written complaint can be filed by a parent or a concerned third party. So anyone can file. There's no limit to the geography. They don't even have to be a resident of the state of Oklahoma to file against a particular school district. It is limited to the provisions in the IDEA, so the allegations must be that the IDEA was violated. All IDEA violations must have occurred more than not 1 year prior to the date of the complaint in order to be investigated. Once they're open, the state has 60 days to issue their findings. When the complaint is received, the State Department sends letters detailing the next steps in the process. Both sides have the opportunity to respond, but it's not like a formal court proceeding where it's tit for tat and people respond directly to what the state is receiving. So the school has an opportunity to submit further documentation, as does the complainant. And the investigation can include any of the following: student confidential file reviews, interviews with parents and or school staff, on-site visits if necessary, and then in general we review all relevant documents to the complaint. The State Department will issue a written decision to the complainant that addresses each IDEA allegation, and that decision includes findings of fact and conclusions of law upon which that is based, and then the reasons that the department has made the final decision. If a violation is found, then corrective actions to achieve compliance will be laid out in that report. The corrective action upon issuing the finding. Any noncompliance found is to be corrected as soon as possible, but in no instance more than 1 year from the time the decision is sent out. Systemic compliance, and so within 1 year of issuing the findings, the State Department will review one or more of the following to verify continuous compliance: policies and procedures, confidential files, reviews student schedules, and interview school staff. So this stems from a prong 2, much like the monitoring, as part of the general supervisory authority that the state has. Resolution options. Parent request in writing to close the complaint. So if the complainant provides notification to us that they intend to close the complaint that they opened, or if a resolution has been reached through mediation, or if the due process is filed in conjunction, if the issues are the same, the due process takes precedent. If the issues are settled in mediation, then the state complaint will be closed. If there are items left over that aren't a part of a mediation or due process, the state complaint procedure will continue. And my contact information is here, as well as a link to the form with all the requirements to open a state complaint that complainants have. It is not required that complainants use that form, although we do provide that form as a model. So you can see that there. And now I will turn it over to Joanne Blades with the Special Education Resolution Center.
I was talking and I still had my mute on. Thank you, Colin. This is Joanne Blades. I'm the program manager for the Special Education Resolution Center. We're part of Oklahoma State University, and we've had a contract with the Oklahoma State Department of Education for over 13 years to help schools and families resolve disputes at the earliest stage possible. Our website is really the best place to find more detailed information about our programs if you want to read about it. It has details about the services we provide. There's training modules you can use with your staff, and those are on communication and collaboration. We have our quarterly newsletters are archived there, and in our quarterly newsletters called the CERC Scoop, we usually have try to keep you up on the latest OSEP issues of, the letters that have come out of major importance, or any kind of new thing that's popped up. We have a lot of cadre materials on there, and we link to webinars that have interesting topics for families and for school districts. And again, our quick link is just serc.okstate.edu. You just put that in, it'll take you right there. In 2010, CERC was honored by OSEP, the Office of Special Education Programs, and CADRE, the Center for Appropriate Dispute Resolution, as one of 4 exemplar programs of dispute resolution in all states and territories. And I always say I was kind of surprised, why us here in Oklahoma? But they told me that for a system our size, we had overcome some major change, and we were reforming all of our practices and policies along best practice lines. So we started our processes early on to try to lower our numbers of due process because, frankly, we weren't seeing issues that needed to go there. Okay, can we go to the next slide? There is no cost to anyone to use our programs because that cost is paid for through our contract. So basically, it's free to you. We serve every school district and every child on an IEP in our state. And requests from our services, they come from both schools and from parents. We have a lot of referrals from parent agencies. We have referrals from Oklahoma Directors of Special Services. We call Andrea. Sometimes she will ask you to call us. The State Department sends people to us. And then we're also in parent rights, so we just get calls. We're here to help you through difficult situations. And that might be hostile meetings. It may just be really tough conversations that you have to hold with parents that you don't really know how to say it, or you're worried about what's going to happen if you do. But you need that safety built into the process. Our most popular service is IEP facilitations, and it's just growing by leaps and bounds every year. So what happens is during an IEP meeting, we send a third-party neutral to the meeting, and that person is neutral. They're not an advocate. They're just there to manage conflict and help all the team members stay focused on the needs of the child, because conflict takes us off in different directions. So they help us keep focused on that child. You access that service by doing an intake with our office. We don't send an IEP facilitator to just anyone who wants someone to hold their hand. We need to do an intake to find out that the situation is really difficult. Both parties have to agree to it, and so we do a lot of phone consultations to get that process moving. Mediation is a confidential, more formal process for times when there are particular issues over which parties have reached impasse in their discussions. So sometimes IEP facilitations, they just can't get through the meeting. You know, there's hostile feelings or there's lack of trust. Mediation, they're discussing, but there's things they just don't agree on. And if there's a particular issue, they can have mediation over particular issues. So a mediation must be agreed to by both parties, and agreed, as Norm said, it comes out in an agreement that is signed and it's enforceable in court. And requests for mediation forms are available on our website and also in the dispute resolution section of the SDE website. We also have due process complaint notices, and those notices basically say that we have a problem, whoever's filing, and if that isn't resolved within about 30 days, then this is going to spring to life as an administrative hearing, and then a process starts from there. When matters just can't be resolved, that's when we see schools and parents request a hearing. And parties request due process when they really just give over the decision to somebody else to make it in accordance with the law. And if you look back at slide 17 later, it will give you the general reasons that most hearings are requested for. The downside of hearings is that the parties lose control of the outcome. And other due process resolution processes, the parties control the outcome. But in a hearing, the hearing officer makes the decision. So during the process of administrative hearings, in that first 30 days, as you heard before, there is a resolution session. And if both parties agree, CERC can send a neutral third party to try and facilitate that resolution. I think last year and this year we have a 100% resolution rate. Our numbers on IEP facilitations have increased dramatically. Our numbers of mediation are down, and our due process complaints sit right at 4. That's an all-time low we've ever had. When we started 13 years ago, they were anywhere from 35 to 50 per year, and they're down to 4 this year. I think 11 is the least next to 4, but I'm sure we may end up having 1 or 2 more, but we've really dramatically reduced it because we find if we can get to the problem early, we can solve it before it escalates to attorneys. Okay, can you go to the next slide? CERC works collaboratively with all the major stakeholders in our state. So, I mean, we help each other. We contact each other, we refer, we ask for help from each other because we decided, we all agree that we need to focus on the needs of the child. So CERC's process in that is to support the discussions that the parties have in a structured setting while people really work through difficult decisions. I'm ready for the next slide. If you're struggling with a situation, just give us a call. We can talk to you about the situation. Most people who call us don't really know what they need. They just know they have a tough situation going on. And sometimes I can give you informal direction or suggestions or just talk to you about it, let you know if there's been recent guidance on something or if it's difficulty with a party. We reach out to the parents, and sometimes they can trust us when they've lost trust with the school. We're very consumer friendly. We don't mind a call. We'd rather you call than not, because what we find is when we touch that case, we get it resolved in some manner before it escalates on, and there's more hurt feelings and more disrespect and more problems. So here's my contact information, and I look forward to helping you to make a positive difference in a child's life. I know you do that every day, and When you hit a bump, that's when you give us a call and we'll help you out. So I'm going to turn it over now to Sharon Long and Ellen Kimbrell at the Oklahoma Parent Center.
Just want to make sure, Ellen or Sharon, if you were speaking, that you might be on mute. I know I'm not hearing anything. Ellen or Sharon, are you guys out there?
Okay, so I'm going to go ahead and take care of Oklahoma Parent Center until they can join us. They may be having some technical difficulties. So Oklahoma Parent Center is a nonprofit. They operate in Oklahoma, and they're funded in part under the Parent Training and Information Centers grant, and the State Department of Ed also contracts with them to provide some supports for families as they are seeking those most appropriate educational placements for their students. Next slide. So some of the things that Oklahoma Parent Center is able to do is they provide one-on-one assistance to callers. They also receive a lot of phone calls from parents and from other people in the communities that have concerns and need some guidance. They do a very good job of helping the parents to understand IDEA, what to expect in meetings, and how to communicate with the school regarding their concerns that they have regarding their child. At times, they will also attend meetings with the parents to help them through that. Sometimes that helps the parents to feel a little more confident as they work with the schools. They provide a lot of training all across the state to parents and to other community members to understand IDEA and how to work together as a team. And their website is full of all kinds of information and resources that will help the parents to understand. They're great resources as well for the schools to also share with the parents to help them to understand their roles and how that they can work together as a team. So they provide a lot of data to us as well. So they gather some information on Oklahoma outcome data, and some of them are our parent surveys that they gather information on and send to us, and current issues in schools. So just the same as CERC, the three of us with the State Department of Ed, CERC, and Oklahoma Parent Center, we all work very collaboratively to communicate regarding who's the best person to reach out to, maybe that parent or to the school to help resolve those issues so that we can address issues as they arise around the state and assist the schools and families to work together. And their referrals from the SDE to Oklahoma Parent Center are up 20% of calls each year. So there's times at the State Department here, we refer those calls to them so that they can help the parents to understand their roles and responsibilities. In the Oklahoma Parent Center, there is their contact information. And again, you know, a lot of their resources are really geared toward the parents, to helping the parents to understand IDEA and working with the schools. But they are also great resources for the schools as well to utilize. And then there's their contact information and their phone number so that you can share that information with families to get that assistance that they may need. And there is Sharon Long's contact information, her email and phone number, and Ellen Kimbrough, which is the Associate Director, to contact them also if you have some questions or concerns.
Yeah, well,
So-
Tina, thank you for that. Yeah, go ahead.
Oh, that's all right. Go right ahead.
Okay. Well, listen, we were sorry. We're not sure what happened with Ellen and Sharon. If you heard Tina just now, you know that she represented the Parent Center extremely well, and we want to put a plug in to you guys there at the Parent Center. And if you haven't noticed, I'm sure you have on this webinar, but you've got some amazing resources available to you as a local director, local administrator, a teacher, a parent, a family member, you know, an adult student with a disability. I mean, Oklahoma is set up nicely to be able to respond to any questions or concerns and walk folks through the various processes for dispute resolution, and more importantly, the more alternative options for preventative measures to the the escalation of disputes, which we all want to strive for. So I just wanted to put that in as a plug for your state. As an outsider, we work with a lot of different states, and just wanted to affirm that Oklahoma is in a great place for having a lot of helpers, a lot of great supports. Are there any questions at this point that anybody would like to ask, or pieces of clarification? We've been watching the chat box. We haven't seen any questions pop up, but feel free to unmute yourself if you've got a question about any of the topics that were discussed today. And Brenda reminds me that if you are muted, press on your phone, you can press *6 to unmute your line, and then we should be able to hear you. All right. Well, with that, let's move forward. And if you think of questions, again, I think you can see you've got folks and resources to go and seek answers to your questions. Let's finish out the webinar with a final quick poll. Based on the webinar today, let's have you let me clear the results, clear answers. And go ahead and respond based on the your initial self-rating. Got a lot of folks in the very low, and somewhat familiar area. So go ahead and got a lot of folks that are now clicking on very familiar and somewhat familiar. And again, as a special ed director, a building principal, a coordinator, a teacher, and as a parent, as long as you have a general understanding that there are provisions for resolving disputes and know where to get answers, you can pretty much view yourself as an expert. As long as if you don't know the answer, you know where to get it. That's important. Oh, great. Clearly, we've migrated from off of the very low and the low categories to higher levels of familiarity. So that's wonderful. We appreciate that. What we'd like to do now, is, before we end, is just encourage you to continue to be aware of the various regulations, both the federal and your state regulations. And then I know that most of you, if not all of you, know that at the local level, you're required to have various procedures, written procedures in place that spell out processes for dispute resolution. And so there's that, and make sure that you're familiar with those. Be familiar with all the resources available. Be proactive in this process. And then if you wouldn't mind, take just a few minutes and click on this survey for us. We need your input to understand your perceptions of these webinars and how helpful they are, and provide some input on how we might be able to make these better for you, because that's the whole purpose of these webinars, is to help build your capacity and your level of knowledge and understanding around various topics in special education. So with that, let me just, on behalf of the state, on behalf of TACE, we really appreciate your time on this webinar. Again, fill out this survey for us, And we wish you the greatest of the rest of your weeks and the rest of your school year. Thanks for what you do on behalf of your families and your students. With that, we'll sign off. And we will leave this window up here for a few more minutes in case there's folks that want to click on it for the survey purposes. Thank you very much, everybody.